Hello everyone, I welcome you all to today's topic Decodified session. The Government of India has made 7 key amendments to the existing Foreign Contribution Regulation Act Rules 2011, which will now be known as the Foreign Contribution Regulation Amendment Rules 2022 with effect from 1st July 2022, and therefore we are going to cover Foreign Contribution and Regulation Act as the topic decodified today. Let me tell you a bit more about FCRA before we move ahead. The FCRA prohibits the acceptance and use of foreign contributions or foreign hospitality for activities that are detrimental to the national interest. All associations, groups, and non-governmental organizations that wish to accept foreign donations must comply with the FCRA. We shall be discussing why it is in news and thereafter the details of it, right? The sequence is going to be why in news and then the details, right? But before that, I would like you all to be informed about the Mains 2022 aid program, wherein you can get help for polity, essay, public administration, and ethics. Do check out the details over here and apply soon to avail the early bird discount. All right. So getting back to our topic, why it is in news. Union Home Ministry has amended the Foreign Contribution Regulation Act FCRA, giving certain relaxations such as allowing relatives to send more money to India freely. The amended rule now allows relatives to send 10 lakh rupees without informing the government. If the amount exceeds, the individual will now have 3 months to inform the government against 30 days 1 month earlier. Fine. The amendment rules also gives more time to organizations to inform the government about opening of bank accounts for utilization of funds received under registration or prior permission category. A provision where an organization or individual receiving foreign funds had to declare such contributions every quarter on its official website has now been done away with. The rules were amended by Government of India in exercise of the power conferred by Section 48 of the Foreign Contribution Regulation Act 2010. Right? Now let's get into the details of the same. Political parties, legislature members, election candidates, judges, government servants, journalists and media houses, among others, all barred from receiving foreign contribution will no longer be prosecuted if they receive a foreign contribution from relatives abroad and fail to intimate the government within 90 days. These persons were allowed to receive contribution up to rupees 1 lakh earlier, but they have ran the risk of prosecution if they did not inform the government about the excess of rupees 1 lakh within the stipulated time. The amended rule makes this compoundable offence, which means now they will not be punished, but they would be fined, right? And the recipient will require to pay 5% of the foreign contribution received. Earlier, such offences would entail prosecution in court of law, right? Now, as I've already told you, the actual act belongs to 2010. The principal rules were published on 29 April 2011. And subsequently, it was amended on April 12 the next year, 2012, right? December 14, 2015 and March 7, 2019. Thereafter, September 16, 2019, again November 10, 2020 and January 11, 2021. And now the rules have been amended again. So the new notification have increased the number of compoundable offences under the Act from 7 to 12, and this is one of them. So the key change in rules of 6 of the Act, the words 1 lakh rupees have been replaced with 10 lakh rupees and the words 30 days have been replaced with 3 months. Rule 6 deals with intimation of receiving foreign contribution from relatives, and amendment will allow individuals to receive up to rupees 10 lakh from relatives abroad without intimating the government. In case the amount is more than rupees 10 lakh, and the receiver will get 3 months instead of 1 to intimate the government. Fine. So as we have seen, there have been so many amendments, which means the ministry is constantly working to ease compliance burden on NGOs. These steps have been taken with the same objective. It will give them more room for compliance and even compound certain offences that were punishable earlier. An official of Ministry of Home Affairs has said so. In Rule 9, which deals with application for obtaining registration or prior permission to receive foreign contribution, the government brought amendments that will now give NGOs 45 days instead of 15 days under the earlier rule to intimate the Union Home Secretary about one or more bank accounts opened for utilization of foreign funds received. The same extension of time for intimation on bank accounts has been offered to NGOs seeking prior permission for receipt of foreign funds, right? In Rule 13, which deals with the declaration of receipt of foreign contribution, the government has deleted clause B. The clause says a person receiving foreign contribution in a quarter of the financial year shall place details of foreign contribution received on its official website or on a website as specified by the central government within 15 days following the last day of the quarter in which it has been received, clearly indicating details of donors, amount received and date of receipt. But this clause has been done away with now. In Rule 17A, which requires NGOs to intimate the ministry within 15 days whenever there is a change in an NGO's bank account, name, address, aims, objectives or key members, the deadline has now been increased to 45 days. All these rules of this particular act have to be followed by all the associate branches outside India or subsidiary of companies or bodies corporate, registered or incorporated in India itself. Fine. So the Rule 20 of the amendment have been brought to ensure applications for revision of an order passed by the competent authority that can be made to Home Secretary in an electronic form as well. Earlier, it had to be made on plain paper. However, the ministry will reserve the right to decide in what form the application needs to be made. Among the offences made compoundable by the government are also those falling under Section 11 and 35 of the Act. So, Section 11 bars individuals having definite cultural, economic, educational, religious and social programs from accepting foreign contributions without registration, and both have been made compoundable with a fine of 5% of the foreign contribution received. Offences under Section 17, Section 19 and Section 37 have been made compoundable with a fine of Rs 10,000 per bank account. Section 17 asks NGOs to open only one bank account for receipt of foreign contribution, but also asks them to open multiple bank accounts to utilize the same. Section 19 asks NGOs to maintain an account of foreign funds received and utilized. The Act asks NGOs to intimate the government about opening of bank accounts within 45 days, failure to do which has now been made compoundable, right? Please note one more thing. All NGOs who intend to receive foreign contribution will have to register with the FCRA and comply with the FCRA, and the registration is for 5 years, which can be extended further if all the conditions of the FCRA have been met, all the standards are met, then your registration can be renewed for another 5 years, right? So Section 37 deals with punishment for FCRA violations where penalty has not been defined and stipulates it as 1 year of imprisonment. Similarly, the offence of failure to intimate the government about change in NGOs' bank accounts, name, address, aims, objectives or key members within 45 days has been made compoundable with a fine of Rs 10,000. I hope you have understood the topic well. Now, let us look at the prelims practice question. With respect to FCRA, consider the following statements. It is applicable to all associations, groups and organizations which intend to receive foreign donations. The FCRA registration is renewed every 10 years. Under the Act, registered NGOs can receive contribution for political activities. These are the 3 statements. You have to figure out which of these is correct and thereafter pick your option. Your options are as follows: A, 1 only, B, 2 and 3 only, C, 1 and 2 only, and D, 1, 2 and 3 only. Fine. So pick the correct option and put it in the comment box below. Now let's check out the mains practice question. The government regulation on NGOs at a time when the country especially requires robust civil society organizations and networks is not desirable. Critically analyze in the light of recent amendment to the FCRA rules 2022. You have to write this answer in 250 words. Send it to us on the WhatsApp to get it reviewed. This is it for today. I shall see you again with another topic decodified. Till then, thank you so much for watching. Stay tuned. Take care.